Hi, I'm attorney Julie Hauf, and I want to continue our theme of fee hearing February, where I've been posting about issues related to fee hearings all month long, and we'll continue to keep doing that here and there since it is such an important topic. But today I want to talk about what happens when you actually go to a fee hearing. And if you're looking at plaintiff's timesheets, you've got the plaintiff's expert, there's going to be that point in the fee hearing where it's your turn to put on some evidence and ask some questions. So I want to go over some questions today that it would be a good idea to consider asking the plaintiff's attorney, who is the one that is there arguing for his or her time. Now, these are by no means exhaustive, but certainly some that I consider in each case where I'm either handling it's my file or I've been retained as the defense expert. So first, and a really common one that we see, if there are things pre-COVID that had been attended in person, we'd sometimes see a plaintiff's attorney adding their travel time in that. That's not something that is compensable for them. So if you're seeing items for depositions or hearings that look like they're taking longer than they should, or a case management conference, ask if that includes the travel time. Ask if there was another file, if it's a case management conference, that they were there on at the same time. Maybe it's multiple files and that time should have been split between more than one case. So all of a sudden your hour and a half for attending a CMC is now down to 0.2 based on taking up the travel time and looking at the other cases that should have been, that time should have been split pro rata. So another question I like to ask is the number of times that this particular attorney has dealt with a similar issue to what is the main issue and what ended up ultimately resolving this case. If they say, oh, I've dealt with it all the time, that means that if you're looking at research time or other motions on the file, maybe they shouldn't have been billed all to this file or spent so long on this file if they've dealt with that same issue 20, 30 times. In the reverse, if this is an issue of new impression for them and they needed to take some time and look at it, that's something that you'll want to know too in order to determine what time is reasonable and what arguments you want to make to the judge. Another one, you'll sometimes see time entries for elementary research. Now, that might mean going back and looking at the rules of civil procedure on discovery to determine whether and how to file a motion to compel. That's something that, especially given some of the hourly rates that are being charged, would be something that you would expect that they already know. Looking at the number of files, asking them how many PIP suits did you file if it's a PIP matter, how many suits did you file in the last year. If they're not sure, you can use the LSOP report that would be discussed in one of the earlier videos this month to remind them how many that is. If it's a very small number and they're seeking a very high hourly rate, that's something that you can use to hopefully get that hourly rate down with the judge. Another thing, elementary research, elementary legal principles that we think, if we've been handling a certain area for a while, that people on both sides would know. I had an example of a plaintiff's attorney that had filed a case in 2019, basically a file and pay PIP suit where I was the expert, and he said his opening line at the hearing was, well, I'm not going to seek a multiplier here. Well, as anyone that practices in this area and that is trying to claim well over $500 an hour should know, multipliers haven't been applicable in PIP cases for years, so we were able to use that to get a very good reduction in the hourly rate that attorney was seeking. Let's see, any orders. If there were any orders that they bring to say, this is my hourly rate, this is what I should be awarded, make sure you ask if the hourly rate was contested in any of those proceedings. If it was an agreed amount, if the other side chose not to challenge it for some reason, that's something that you definitely like the judge to hear. Let's see, what else do we have? Looking at their background, take a look at their website, take a look if they have a LinkedIn or other social media page, maybe they've been posting videos on YouTube. Is all of their relevant experience listed there? I've had times where plaintiff's attorney has come in and said, oh, I was at this firm and I did PIP for this amount of time, but it actually wasn't even on their LinkedIn page as a past place that they worked. Or you go to look at an attorney's page, it's an entirely different area of practice, like criminal, and there's no mention of PIP or property work or BI work at all. All of their publications or orders that they have had published all deal with other things. So that can be a good way to get hourly rate down as well, but this isn't their main area of practice. It's something they might do on the side, but again, maybe not entitled to the same hourly rate that someone that's been doing this for 20 years and practicing almost exclusively in this area would be getting. what staff do they have? What staff was helping? As you all know, most times on the timesheets that we're getting from plaintiff's counsel, you're only seeing attorney time. So you want to ask what paralegal, what admin help that they may have had, what tasks did these people do for them? Did they draft template documents for them and then they reviewed and signed them? If that's the case, should you really be paying a 0.3, 0.4, 0.5 for that particular document? When looking at templates, ask if they use templates, ask how those are used, pull some examples from some other cases, whether it's discovery, a complaint, or even, hopefully, and this can be a really good find, a motion for summary judgment that looks substantially similar, that there's only some fact-specific, case-specific details that have been changed, like the name of the insured, the dates of service, or the codes at issue. If you see something like that, have them agree with you that they've used this template in the past. This isn't the first time, it's not the last time it's been used. Have them guess how many times they've used it. If it's that initial discovery, would you agree with me, counsel, that you've used this in the last 120 cases that you filed that are showing on this LSOP report? And when you use the same document that many times, chances are even that 0.1 might seem a lot, so that could be a good way to get something down to a paralegal charge. If it's something they just look at, sign, automatically goes out if they're using that kind of help in their office. Do you have in the file discovery that seems to completely miss the point of the case? So, for example, in a roof case, are they sending discovery request about a plumbing leak? In a PIP case, is it there's no deductible at issue, which you've already admitted in your answer to the complaint, but they're sending you discovery about the deductible, sending you discovery about exhaustion, or whether or not you made any payments to or knew of a workers' comp claim for the accident happening during the course and scope of employment. Have you already admitted that the treatment is reasonable, related, and necessary, yet you're still getting discovery on this issue, which is not going to be a point that's litigated in the case? Ask when they knew that was an issue. Why did they send the discovery? Didn't they go back and look at the answer? Did they read that answer? Did they know that this was admitted and not going to be an issue in this case? These kind of impeachment questions, how well do you know your file? What decisions did you make? Why did you do this when you did it? Can all help paint a picture for the judge that some of the time entries here are not going to be reasonable and either should be reduced or not awarded at all. One of the last areas I'll cover today is updates to the client. So you see sometimes on the files, on the timesheets, that they have maybe every 2 or 3 months a 0.2 or a 0.3 giving a status update to the client. Look around that time entry on the sheet and see whether or not there was something significant that happened, or you're just seeing this entry with a frequency, a certain pattern. So let's say, okay, I'm seeing this every 3 months, whether or not anything's happening on the file. There might have been a 6-month gap in any pleadings on the file, but again, we're still getting these 0.2 and 0.3 status updates to the client. Ask how many files they would have had active with that client at that time, and if all of those calls that were made on this timesheet are only related to this case, or did they also discuss the status of some other litigation? Does every file that he has for this client have, or she have, a similar grouping of time and status updates to the client? And again, if we find that there is a 0.3 every 3 or 4 months, even every 6 months, but several cases are being discussed, that's going to be a pro rata reduction that would be appropriate there. So hopefully this has helped you start getting your questions ready for when you have a case that is going into a fee hearing, giving you, again, some insight on how to prepare for your fee hearing and what things you want to be looking for on the timesheet. As always, you know where to find us. I serve as an expert witness on attorney fee issues around the state. Always happy to take a look at something, always happy to help. Take care, stay safe.